All right. Both James Comey and Letitia James got their cases dismissed by a Clinton judge. It was very funny. An Obama judge appointed a Clinton judge to dismiss these indictments. I'll talk about this more in a moment. The cases, it's not really proper to say the cases got dismissed. The indictments got dismissed. The Senate's refusal to even consider Trump's U.S. attorney nominees. This is a real problem. Trump has nominated people to be U.S. attorney generals, and the Senate hasn't bothered confirming them, often because of a process called blue slips. Blue slips give local state senators, federal U.S. senators, a veto over a president's appointment of someone to federal office. That's one of the reasons you might hear, like, you see a liberal judge and someone says, well, that was a Reagan appointed judge. Well, if it was a Reagan appointed judge out of Massachusetts, he had to satisfy the liberal senators in Massachusetts. So they act as a filter. And a lot of the people Trump would like to be U.S. attorney generals are getting vetoed by these state senators. And so they're not in office. So he's having to put in acting U.S. attorneys and temporary U.S. attorneys, and they have time limits on their authority. And then there's a weird rule that Congress has created that says if a U.S. attorney has not been confirmed in a certain number of days, I think it's 120 days, and there's been no confirmation, not only is that person out, but then the privilege to appoint a U.S. attorney falls to the judicial branch, which is just an insane rule because it's a massive separation of powers violation. Why would the Article 3 judicial branch, the apolitical branch of government, why would they have the authority to appoint a prosecutor within the executive branch? I mean, prosecution is inherently an executive function. So it's an insane rule. And I expect if it were really challenged, it would be found unconstitutional. I think it was created for just administrative convenience. Like if the legislature of Congress is so screwed up, they're not getting anything done, we need to have prosecutors in place, so we'll just let the judges do it, pick somebody. But it's a tremendous separation of powers violation. But it is the existing rule. And that's hurting Trump right now. And I believe it's justification used here to say Lindsay Halligan was not properly put in office and therefore her indictments are unlawful. I think that's all bad law, by the way. I think the judge is wrong on this ruling to dismiss these indictments, but I also don't think it matters. So Judge Cameron McCowan, for reasons I'll talk about in a moment, Judge Cameron McCowan Curry ruled that interim U.S. Attorney Lindsay Halligan's appointment to the Eastern District of Virginia was invalid, voiding her authority to bring indictments against James Comey and Letitia James. The dismissals of the indictments were issued without prejudice. When something's dismissed with prejudice, it means it's the end of it. You can never bring it back to the court. Without prejudice means you can come back. You just have to do it the right way. Meaning the charges can be refiled under a properly appointed U.S. attorney. Conservatives call Curry's ruling political cover for two top Democrat power players who have long avoided accountability. I think that's right. That's the correct description. Ariana Presley writes, she says, the prosecutions of Letitia James was never more than a baseless racist attack on a strong Black woman, Black capitalized, of course, just doing her job. Carry on with your good work, sis. Tish James. The evidence against Letitia James in this federal mortgage fraud prosecution is overwhelming. I mean, it's rock solid. All the mortgage documents she signed are full of lies on multiple levels, many lies, different federal documents, tax documents, mortgage closing documents. They're all public record. The government's got all of them. This is an airtight federal mortgage fraud conviction. Airtight. So that's why they have to attack it on all these procedural grounds, because on the legal merits, she is totally effed. Totally effed. As I say here, the case, by the way, they say the case was dismissed. The case against Letitia James, mortgage fraudster, has not been dismissed. The indictment has been dismissed. That's one step in a case prosecution. And it was dismissed on technical grounds that the prosecutor was not properly nominated, not on legal merit. So the dismissal has nothing to do with the legal merits of the case, which, as I said, are airtight. The case remains airtight. They'll just re-indict her. They'll put her in front of another grand jury and they'll show them the same documents full of lies under oath, penalty of perjury, and all the rest, and she'll just be re-indicted. So nothing's improved. for Letitia James. It's just a delay tactic. And the same is really true, by the way, of Comey. So on the legal merits, the case against Comey is airtight. It's airtight. He committed perjury. There's no question about it. It's all on video. He committed perjury, and the documents that expose the lie. Now that they were found in that secret room in the FBI headquarters. Of course, Comey used to be director of the FBI before he was fired by Trump. I'm sure he thought all those documents had been destroyed. They were in burn bags to be destroyed. It just didn't happen. So now that they've been disclosed, his perjury has been disclosed, and perjury in the course of a congressional investigation is obstruction of Congress. That's another felony. So the case against James Comey is also airtight. He's got a slightly additional wrinkle. He could, of course, be re-indicted. He was very close, within 2 or 3 days, to the statute of limitations expiring on his case. But I don't think that'll matter here for reasons I'll explain in a moment. Here's Pam Bondi talking about all this. Let's hear what she has to say.
If I could just get your reaction to the James Comey, Letitia James cases being dropped today. Back in Washington, James Comey put out a video. He said this matters most because a message has to be sent. The President of the United States cannot use the Department of Justice to target his political enemies. Your reaction to the cases being dropped into that specific message?
Sure, we'll be taking all available legal action, including an immediate appeal, to hold Letitia James and James Comey accountable.
So there's 2 things they can do, right? They can appeal the reasoning of the dismissal that, in fact, and the argument here for Trump, for the administration, is even, first of all, that Lindsay Halligan was properly appointed. Even if she wasn't properly appointed, the indictments were signed off on by properly appointed prosecutors, so it shouldn't matter. It should be legally irrelevant that she wasn't properly appointed, which, of course, they reject. But even if that's true, other prosecutors properly appointed prosecutors signed off on the documents. It's like if you had a paralegal do something. It doesn't make things illegitimate if it's signed off by a real lawyer. And so they're going to attack the merits of the dismissal. But even if the dismissals go forward and survive attack, they can just re-indict.
For their unlawful conduct.
What is your reaction to his statement?
I'm going to keep going on this. I'm not worried about someone who has been charged with a very serious crime. His alleged actions were a betrayal of public trust.
All right. Well, Pam, you could have done better. Like you didn't know that question was going to come up. You sounded like you were surprised by the question. Her demeanor there is kind of weird, isn't it? It's like she's reading off a piece of paper that someone else gave her. Like she's not in charge of that meeting. Isn't that the vibe? That's unfortunate. When you get these questions, when Trump gets a question like this, does he ever act like that? Like he's got to read off a piece of paper? And does Trump say, you know what? I am so effing happy you asked me that question. Now I get to be the boss. I get to be the alpha. I get to answer that question decisively with authority. Thank you for the opportunity. I love this. I love being in the arena. The vibe I get from Pam Bondi here is like, listen, I came here for a specific task. I'm just here to do this task, and I don't want to be distracted from. And that's not what winners do. It's terrible. A dismissal of James Comey and Letitia James cases is not based on the legal merits. This is a technical ruling that will be appealed. Expect the cases to be refiled and to move forward eventually. The dismissal is likely only a delay of the inevitable.
Is getting dismissed. The judge ruling the appointment of interim U.S. Attorney Lindsay Halligan violated the Constitution. The judge also criticized the DOJ for allowing an FBI agent who viewed Comey's privileged materials to testify to the grand jury. Now, the judge also tossed the case against Letitia James. Donna, we are just getting this on the wire. Talk to us about your top line thoughts in this moment.
Well, frankly, I'm not really surprised about the appointment of the Attorney General on that situation. I did think that was going to be an issue, and I did think from the very beginning that Comey was going to have a valid legal argument. And what's interesting about the decision is it doesn't go to whether or not crimes are actually committed. It just goes to the way in which the prosecutor was appointed. So I'm not surprised legally when it comes to that issue.
Right. Do we foresee at all then an appeal or a different than prosecution, a second bite of the apple then with procedural things intact?
Yes, it's a 29-page opinion. I was just reading through it. So sorry if I look distracted during our segment. It doesn't get to the claim of malicious prosecution that Jim Comey was making. So this is solely the appointments clause, and that's why you have both cases dismissed against both individuals.
Right. And it is
So it's based solely on the appointments clause. In other words, nothing to do with the legal merits. It only has to do with whether or not the prosecutor, Lindsay Halligan, was properly appointed in the case. Mike Davis says there is overwhelming evidence from FBI Director James Comey lied to Congress and obstructed a Senate investigation into Crossfire Hurricane, the biggest scandal in American history. There is overwhelming evidence. New York Attorney General Tish James lied on her mortgage application and committed bank fraud. That's all true. The prior U.S. attorney refused, the one that was in before Lindsay Halligan, that Trump had to fire, refused to prosecute these Democrats, saying there wasn't enough evidence, which is bizarre because, of course, the evidence is airtight. The prior U.S. attorney refused to prosecute these Democrat operatives, so the attorney general picked a new prosecutor who was unafraid to follow the law. The Democrats' response, an Obama judge hand-selected a Clinton judge, and the Clinton judge tossed out both indictments. And the first sentence in both is nearly identical. The Clinton judge personally and gratuitously attacks Lindsay Halligan, making it crystal clear this judge is a Democrat partisan. Unfortunately, we have two systems of justice, one Democrats weaponized against enemies and one Democrats weaponized to protect allies. The Justice Department must appeal, and it must move aggressively to bring charges against the lawfare Democrats. Now, I think the appeal is going to be difficult for reasons I'll get into. But look at the first sentence here in this order. By the way, Lindsay Halligan's rather attractive, and the judge who issued this order, let's see if I can get a picture of her. Let me do a quick search here for, because we like to have fun on this show. The Judge Cameron McGowan Curry is on the right? Look at that. She's got the ugly short haircut. Lindsay Halligan's on the left with the long flowing locks of hair. If you had to pick which one of those two were more attractive, I think we would know. And there's nobody that hates attractive women more than unattractive women. It has been my universal experience. So there's Pam Bondi. There's the clip we just saw. Oh, so this unattractive judge. Did it pop up properly? Did you guys see it? That was the image. And the first sentence in these orders, the unattractive judge characterizes the attractive Lindsay Halligan as Lindsay Halligan, a former White House aide with no prior prosecutorial experience. Why is it necessary to say that? That's not relevant to any of this. If she had proper prosecutorial experience, it would not change any of this legal analysis. It would change nothing. The judge just felt she had to throw that in. And I think it's really funny because most of these judges don't have any prior judicial experience. Let me ask Grok. Most of these federal judges don't have any prior judicial experience before they're made a federal judge. Let's ask Grok. Let's see, I'll pull this up so we can all watch it. Describe the prior judicial experience of federal judge before she was raised to the federal bench. And I don't know what the answer is. Maybe she was a judge prior, but if I were a betting man, no prior judicial experience. How could I predict it? Judge Cameron McGowan Curry had no prior judicial experience before her appointment to the United States District Court for the District of Columbia. How good am I? And yet she has no shame. She has no shame writing this line about Lindsay Halligan. Lindsay Halligan, a former White House aide with no prior prosecutorial experience. Oh, man. You can't make this shit up. I swear to God. All right. My lawyer, great lawyer, Ron Coleman, he summarizes a Sam Antar post here. And I'm going to share the Sam Antar post too. But I like the way Ron summarized it. He's just quoting here from Sam. He ruled Lindsay Halligan's appointment violated the appointments clause. That's it. She did, the judge. Did not rule vindictive prosecution, did not rule that the evidence came from a fringe blogger, as Letitia James claims, did not rule that Bill Pulte and Harm in charge of the federal mortgage agency, did not rule there was a lack of evidence, dismissed without prejudice so the case can be brought back. So all of this, talking specifically here about Letitia James. Now, Sam Antar is an interesting guy because he's a convicted criminal. There used to be a electronics and appliances store on Long Island, New York, in the New York City area when I was growing up. called Crazy Eddie. And they'd have these TV commercials in the middle of the night with this guy, Crazy Eddie, get these crazy deals and Crazy Eddies. And they were involved in a giant financial fraud scheme involving their accountant, their bookkeeper, who was this guy, Sam Antar. And he was caught. They were exposed, and he was prosecuted. He was convicted. I think he did time in a federal penitentiary. And then when he served a sentence, he came out and he's become an expert on detecting the same kind of financial fraud that he was involved and convicted of. That's what he does today. And he's the guy who exposed most of the Letitia James mortgage fraud, financial fraud. He exposed her. And he did that by simply looking up public records, mortgage documents, titles, all these things are public records. And he brought it to light and exposed the Airtight case against her. And in Letitia James' filings with the court, her arguments for why the case should be dismissed on the merits with prejudice, she says, well, the evidence against me was brought to light by this fringe blogger. What difference does that make where the evidence came from? Is the evidence legitimate? Yes. Did you sign these documents under penalty and pain of perjury? Yes. There's no question. It's not like Sam Antar fabricated these mortgage documents, fabricated your signature and put it into the official records. That's not what happened. Anyway, Judge Walker just dismissed USA versus Letitia James, but not on the merits. Oh, well, there's multiple judges involved, but he ruled Lindsay Halligan's appointment violated the Appointments Clause. That's it. Not vindictive prosecution. That didn't win for her. Not fringe blogger. Not Pulte misconduct. Not lack of evidence. Dismissed without prejudice. That means the Department of Justice can re-indict Letitia James tomorrow with a properly appointed U.S. attorney. Meanwhile, the evidence doesn't disappear. Her text, my documents look suspicious. Her tax returns claiming investment property, her financial disclosures, her bank records, her niece's utility registration at the house in question with the fake mortgage. Her lawyer filed 50 pages attacking me, Antar, Bill Pulte, the investigation's origins, and the judge ignored all of that. He ruled on a technicality the DOJ can fix in 24 hours. Letitia James is not exonerated. She's not acquitted. She's not vindicated. She's in the same position as before, except now the evidence is public. The Department of Justice response is on the record, and everyone knows what's in her own documents. The documents don't have an Appointments Clause problem. The fraud is still fraud, and that's 100% the case. Chad Mizell, he's a lawyer, works for the administration, the Trump administration, says, because the Attorney General and other lawyers, properly appointed Attorney Generals, ratified the indictments, even if Lindsay Halligan was not properly appointed, and he says she was, it wouldn't matter. Think about the logical conclusion of the judge's opinion. All prosecutions in the Eastern District of Virginia would be invalid regardless of who worked on them or who in Maine Justice, Department of Justice in the Capitol, signed off. Completely unworkable, but more important, completely wrong. So that's attacking it on the merits. Let's see. My buddy Bill, Shipwrecked Crew, he makes a point here on the Vacancy Act. The Vacancy Act is that law I described that says if you don't have a U.S. attorney in place, you nominate one to the Senate. They have to confirm or not. If they haven't gotten around to doing anything for a while, you can appoint a temporary U.S. attorney for, I think, 120 days. And at the end of that 120 days, if no one is still confirmed, then that temporary U.S. attorney goes away and the court, the judges, a panel of judges in the district gets to select a prosecutor. I think that's bad law. I think that's a violation of the separation of powers. I think that's a violation of the non-delegation clause of the U.S. Constitution. But it is the rule on the books, and the lower courts, the district courts, the unelected black robe tyrannical inferior district trial courts are going to follow it, especially when it serves their political interests. That's the core of the argument against Lindsay Halligan, this Vacancy Act argument. And it's been an issue before because the Senate has been slow walking other U.S. attorney candidates through the Senate. And so this has come up before. We've seen it in other districts. Where we had temporary people in place and then they had to be dismissed because the 120 days was expired. And the court said they could pick somebody. And now it's being litigated. So the funny thing is, if the courts do assign, they choose a prosecutor, Trump is free to fire that prosecutor instantly. Like the court can nominate a prosecutor, and as 1 second later, Trump can fire that prosecutor nominated by the courts. Anyway, Bill says the administration has lost the Vacancy Act argument 5 times with 5 different judges. I would not expect winning on appeal here. So you need to have a plan B. And the plan B is to re-indict with a different prosecutor. Let's see. A lot of people misunderstand that. So this guy says the way this judge interprets the 120-day rule, the Vacancy Act rule, produces an outcome that defies basic logic and collapses under its own absurdity. It's fundamentally irrational. This was not a judgment guided by reason. He objects to the judges being able to appoint a prosecutor if the 120 days expire. But that is what the rule says, my friends. And so that's what the lower courts are enforcing. Julie Kelly also says, this is crazy talk when the judge refers in her opinion to the 120 days, and then the judge gets to appoint a prosecutor. She says, this is crazy talk by Judge Curry. Consider what she means, that federal judges, not the president or attorney general, have the authority to appoint a U.S. attorney after an interim appointment has expired and until a Senate confirmed replacement is put in place. That's objectionable on separation of powers grounds. I agree. But it is the rule. It is the rule. I think it's ridiculous, but it is the rule. Now, with respect to Comey, there's some concern about he was so close to the statute of limitations. Have those expired now? So it's all over? The answer is no. There is a procedure for this under U.S. Code. If someone's been indicted before the statute of limitations and afterwards it's discovered there's a problem with that indictment, you get 6 months to bring another indictment. So you pause the expiry of the statute of limitations for a 6-month period. So there's time to re-indict Comey. And even if you did not have that 6-month grace, another path is suggested by Robert Barnes, attorney Robert Barnes. Many of you know him. He argues that you can always go for conspiracy to obstruct, for example. And the interesting thing about an conspiracy charge is conspiracy is just 2 people or more, 2 or more people agreeing to commit a crime and then taking some affirmative step in the commission of the crime. That's what a conspiracy is. And the interesting thing about a conspiracy, because there's a agreement and there's a planning and there's an execution and there may be a cover-up. So it's ongoing. It's not like a liquor store robbery that happens in an instant, right? It occurs over a period of time. And what that means in terms of the law is that the statute of limitations does not begin to run out until the last step of the conspiracy. And the last step of the conspiracy can be something that happens long after the crime itself. So if there's a cover-up after the crime, the cover-up is part of the conspiracy. So the crime might have been committed in 2020, but if the cover-up is continuing through 2025, well, the statute of limitations hasn't started running down yet because the conspiracy is still ongoing. And this can create complications for people who enter the conspiracy early on and then leave because they may think to themselves, hey, my involvement with this conspiracy was in 2010. I stopped in 2015. I haven't had anything to do with this in 10 years. And the statute of limitations is supposed to be 3 years or 5 years. The trouble is, if you were ever in the conspiracy, you're forever part of the conspiracy. As long as there's one other member of the conspiracy still operating the conspiracy, everyone who was ever involved is still part of that conspiracy. So their statute of limitations doesn't run out either. The only way to escape that problem as one of the co-conspirators is to formally exit the conspiracy, and that requires basically an announcement to the authorities, which obviously people don't tend to do. So the point is of Robert Barnes is if Comey was doing stuff in a conspiratorial manner, which he pretty clearly was. I mean, he was working with other people to do all this. And there were any activities of that conspiracy still ongoing, well, then the statute of limitations has not, in fact, begun to run. So it doesn't become an issue in bringing the prosecution.